Hi guys, welcome back to Battle with Ola. This is Mujola Olua and I'm super thrilled to be here once again. We want to continue today the series, What Does a State Council Do? And like I have already said, this is an experiential narration and explanation of what a state council does. Remember that the channel is to chronicle my law practice experience and talk about law and more law generally. So I'm sure that the series has been a blessing to as many as have started it and as many as will still watch it. So this is the third video where we're talking about what a state council does. The last two videos we talked about filing a counter affidavit, then we talked about moving a counter affidavit, both generally talking about opposing a bail application. Why, when, where, how, and who that is a state council. We've talked about all that in those two videos. So today, we want to talk about something else or other things that a state council does. We'll talk about now that the bail has been dispensed with, whether the court has upheld, the application or rejected or refused the application. What's the next thing in a criminal trial? So today we are going to be talking about contacting witnesses, bringing them to court, and prepping witnesses for trial to give their testimony. So those are the things that we'll talk about. It seems it looks seemingly easy, but when we go through, how it is done, how a state council does it, and how I did it when I was prosecuting for a state government, you would understand that it is no mean feat. It is not a child's play. It's not child's play, and it's very crucial. It's at the crux of criminal litigation, especially in Nigeria. Generally, when a matter has been assigned to a state council to prosecute for the state, we talked about bail, so probably we've dispensed with the bail in the particular matter. Now it's time to get witnesses, and honestly, I feel like we've done where we did this for all types of crimes, name it. I've brought witnesses to court for, murder, manslaughter, attempted murder, kidnapping, forgery, robbery, armed robbery, stealing, unlawful killing, unlawful possession of firearms, rape, all sorts of crimes. So how do we get witnesses? How does the state get witnesses? And this is important because most of the time when the court throws out a case for want of diligent prosecution, it is because the state cannot get witnesses. And defense counsel, they leverage on this a lot. It's a very funny situation. I recall that we were once in court for an unlawful carnal knowledge matter, and we had tried our best to get, the witnesses, which were mainly the nominal complainant, that's the father of the defiled girl, an underaged girl at the time, a minor. So the father, I think the mother, and then the girl herself. So and then the police. So I'll explain why these things are sometimes difficult and insurmountable. So we have tried our best to get them. We called the numbers they left at the police station. We had written letters to the police. We had done all we could within our own power and wherewithal, and we couldn't get them to court. So on this day, we were in court to take another adjournment, just to facilitate their presence in court, so that our case could go on. And then this defense counsel stood up as when the state stood up, to say that, oh my lord, we have not been able to get them. We'll be asking for a date, to enable us to do this and that. Defense counsel then stood up and said, my lord, they are not ready to prosecute this case. In fact, they don't even know where their witnesses are. My lord, I have their witness in court, and they have told me they have written a letter. He brandished the letter to say that they are no longer interested in this matter. Can you imagine that? So defense counsel, they leverage on this a lot. Sometimes when I tweet some things or say some things on social media, people do not know that I'm talking from experience. And in fact, there was a time that I had put a comment about criminal litigation. A company or an establishment had taken it to their Instagram handle, and then I went to look at the comment section on Instagram, and people were saying all sorts. Some people even said things to the effect that I never even, engaged in criminal litigation, or I just started practice, or I was just called to the bar, sorts of things. I saw one of my classmates and co-mates, who had met me in court as a prosecutor. She was in court for another matter. She was defending me in the comment section, and it was just so funny. It was so funny because people come at you because they do not know where you're speaking from. That's why it's important when you're holding opinions on social media, be very balanced and grounded in your opinion. Don't attack everybody as if you have the best or final say, because you don't even know where they're speaking from. I am speaking from my own experience. I'm telling you real life situation, what is obtainable in the real world. But you are there behind your keypad telling me all the nice things that you tell me, because I choose not to react to those things or get angry about them, because people speak from ignorance sometimes. So he stood up, and then it was shocking and hilarious, because you are telling the court that they are not they're not interested in prosecuting the matter, and that we're just beating about the bush. You have brought them to court. This is our witness that we have looked for and have not found. Thank you for bringing them to court. So my director stood up, who was chief counsel, she stood up and was like, "My lord, we are very grateful. The state is grateful that Mr. So has brought our witness that we have been looking for. My lord, the state would now like to call prosecution witness number 1." And so we asked the man, the father of the girl, to step into the witness box. The defense counsel was flabbergasted. He was completely flustered. He had no idea that it would turn out that way. It was very fun. The judge was looking at all of us, so wondering the drama that we were performing. But my director insisted that no, we are putting him in the box. You have brought him for us. So he had brought the witness, thinking the judge will lambast us, which is actually a frequent, because of the circumstances that I will explain as we go on in this case, is quite frequent, for the court to come down heavily on us. In some instances, when we have not been able to repeatedly bring our witnesses to court. So maybe that was what he was expecting. But now the judge said, "State counsel, what do you want to do?" We said, "My lord, want to put our witness in the box. We thank him for bringing our witness." And we opened that case that day. Probably thought that the court would dismiss the case, but that's not how to go about it. Even if you have a witness that we're looking for, the way that some defense counsel go about this thing is that they think that it's a fight. I've repeatedly said it on this channel that law practice is not a fight. It's not the Third World War. So don't make an adversary of the other party. No, don't do that. Several times I've had to call defense counsel myself, to ensure their presence in court, just so the case can go on. I had to join a group where I would even be getting their numbers, so that I can call them. And on days when we have brought our witness, we have gone through a lot to put our house in order, their absence in court will not delay us. So we do all that is in our power. I worked with a wonderful team. Especially my team members that we were on the same grade level, fantastic people. 3 of us, we were just so, poised to do the good work, the hard work. And we are really grateful for how far we went, while we were prosecuting. So before we had to, do some other work in other department for the state, of course. So that day we opened the case, and we took our first witness that was graciously brought to us on a platter by the defense counsel, and then we adjourned for continuation of trial. So how does the state bring witnesses to court? When a file is assigned, let's say I'm a state counsel and I'm the prosecutor in charge of this matter. So I wrote a whole article on it. That's the article on the screen. I want you to read it. The link is in the description box, where I explained, the challenges of bringing prosecution witness to court, and I even proposed that perhaps witnesses could be incentivized, so that they can come to court, and witness protection be strengthened. It's very important. It's the bane of criminal litigation in Nigeria. That's why when I talked about bail, I was explaining that sometimes state counsel will oppose the bail, because once the accused person or defendant is on bail, they will no longer come to court. If they jump bail, the Nigerian police, correctional facility, and the entire prosecution arm are not well equipped to track them down. As at the time of making this video, which is 2024, January, they are not that equipped to track them down and bring them back. So it's better if they do not escape from our hands at all. Because when people keep escaping, trial is stalled and the court is forced to dismiss. How do you think the victims feel? And what kind of message are we sending into the society? That if you can get out on bail, you have escaped the arm of the law. So people continue to commit crime with impunity. It doesn't work well for anyone. So it's important, if a defense counsel watching this, I've been a defense counsel before, and I'm probably going to be a defense counsel much later, but it's important for you not to take the state as your adversary. They have a lot of constraints, that some are due to administrative bureaucracy, some are due to several other things, but see the state or the prosecutor as a team member, except they are deliberately not playing ball, that is not doing their own part, as a team, trying to get to the end of justice together. So when I get the file, what I do is I read through the file and I look at the statements of people that have given statements to the police, because normally this is the way crime goes. When a crime is committed, people report at the police station, so the police take statements. Most times those people that give their statements at the police station end up being the witnesses, that will be used in the case. So I look at the list of witnesses that was filed alongside the charge by the legal officer that issued the legal advice, that is by the state counsel that issued the legal advice. I look at the list of witnesses, and then I look for their names and their statements given to the police, and then I begin to call those phone numbers that they have left with the police. I call them, then I try to ask them. It's a very funny situation, and most times we had to do this from our own pockets. We were not paid for this most times, but we just had a passion to work. I'm not going to talk about the financial aspect of doing that, but this is what we did. This is what I did, as a person and as a team member, a prosecuting team member and a prosecutor. So I'd call the person and say that, oh, I am so I'm calling you from the Ministry of Justice in so place. I'm calling you regarding this incident that happened in your estate, for instance, or at your house, or that happened to you on so day. Do you remember? Then when they confirm, I now say that, okay, the case is now in court and we need you to meet us in court, as a witness. Most times we ask them to meet us in court because there's no point coming down to our office. But sometimes some want to come to our office before that day so that we can go through the file together, no problem. So then are you going to come? Should we expect you? And if they are saying no or reluctant, I try to find out what the reluctance is about. Sometimes people express sometimes people express their shock. You mean that case is in court? After all these years, because the day a crime is committed is not the day that the defendant is charged to court. Sometimes it takes years, sometimes months, and sometimes it's so swift it takes just weeks, before they are charged, because there's a process. And sometimes even the police they do not duplicate the file to the office of the public prosecution department on time. And sometimes they do, and then some other things catch up with the file. But it takes time. So sometimes people are surprised that you mean that case is finally in court. They are still on that. Some people even react like they're still on that matter, like they have moved on with their lives. So you people should do whatever you want to do. Some people tell us they are not coming. Some people say that, oh, they've left the organization. I remember there was a petroleum theft armed robbery that we were prosecuting, and when I would call the person that was the star witness, because when I read the file, I look at who are the star witnesses, or who is the star witness, the person whose testimony is the most important. Then I look at who are the the supports, the assists. Then I look at who is the IPO, or who are the IPOs, the investigating police officers. So we call both civilian witnesses and police witnesses. We have to get them to court because police does most of the investigation, except it's another facility like or agency like DSS. If it's DSS also, I just call the DSS people and get them to court. So sometimes some people tell us in the petroleum robbery case, they were supposed to deliver petrol tankers that deliver petrol from one station to another. So these people robbed the tanker. I think maybe they drove the tanker away elsewhere. So it's been a few years. So when I called the guy, he let me know that he was no longer working with that petroleum company, that he had moved to another city and was now working in another company. So he then told me who to call. But I was trying to see if he could still come, because if he can come and testify on what was his own experience, what he put down in his statement, it is still good and useful, because whoever is coming is going to be talking about what he has documented, which will be hearsay, which may be, and which is bad for business anyways. So sometimes people have left, they have moved on. There was a robbery on some students of the university, in the state, and then when I started to call them one after the other, some told me that, they had already left the vicinity, they were in another state, they had traveled and all of that. So sometimes people have moved on with their lives by the time it's time to bring them to court as witnesses. Sometimes people are just reluctant. They think that it's not that difficult, like it's nothing serious. You made these cases in court, I don't want to come. There was an attempted kidnapping and robbery that happened in the matter, and I tried to bring the two women that were affected and that had given their statements to the police. They had even been robbed of some monies. I tried to bring them to court, and then both of them didn't show up. One even told me that she had traveled to a faraway state, and she sounded like the money is negligible, while you, like, it's not that deep. Some people make you feel like that. In a murder trial, they called the mother of the deceased, and she was lamenting that, do I want her to continue to remember her deceased son? She's not interested in the matter. Whatever we want to do, we should do, and we should not call her again. So many things happen, and these are some reasons why the state cannot bring these witnesses to court. When the matter happens, everyone is eager to report to the police. But when it's time to give evidence, not everyone is eager to come to court to give evidence. Some people are even afraid for their lives. There was an armed robbery matter that we're doing, was a notorious gang I'm not going to mention, and it was a multi-defendant matter. It was a tough matter because there were so many defendants and as many lawyers, representing the defendant, so many lawyers, and the star witness in that matter, a man was building his house, and then there was a clash of Omoniles, who were also gang members, and then they killed, somebody died, they murdered, I think one faction's head, and then the other faction's head also died in custody and all of that. So it was murder, an unlawful society, the charge was around that. And then when I called the man, the owner of the house that was being built, when they were asking him for money, monile wahala. If you're a Nigerian, you know what that means. Land grabbing issues, people that say that you have to pay them after you've bought the land, before you can develop it and all of that. So the man said he was afraid for his life. As a matter of fact, it took a while before he would pick my call, before I could get in. So he was afraid for his life. He said he cannot come to court. And we, witness protection is not that strong in Nigeria. So, we thought about I think we eventually did we take out a subpoena? I'm not certain. But some of these things are constrained. So he was afraid for his life, and he didn't come to court. Even the prosecution witness, the investigating police officer, was being threatened by the gang members. Even as they were in custody, they were threatening him, even when we put them in the dock and the trial was going on. In open court, they were making threats at him while he was in the witness box. So some of these things are things that make it difficult for state counsel to bring their witnesses to court. Sometimes the family of the offender would have gone to prevail upon the victims not to press charges or not to go ahead with the case. So while state counsel is running after them, they are running away, because now these people have come to say, don't do it, we'll pay you, or we are all human beings, we are this, we are that. So it makes these things difficult. People are always eager to report at the police station, to write statements in the heat of the moment. But when they realize that the state has now taken it up, and is prosecuting the matter, sometimes they shy away, they move back, they abscond, and then we come to court, and the defense counsel is saying, "My lord, I hereby urge the court to dismiss this case for want of diligent prosecution." The state is not serious. The state is nonchalant. The state is not ready. The state is this and that. It's easy for defense counsel to say this. If I were defense counsel, so I'd probably say some of these things, so no excuse for anyone. But these are some of the constraints that the state has. Also, sometimes when we bring witnesses to court, we have to pay them, We have to pay them transport fare now, not pay them for the witness or the witnessing, but pay them transport fare. There was a time that a community had been robbed, and then the witness that my colleague brought to court was I think it was the Community Association of Landlords, the head or a security guard in the community. So he was coming at the expense of his own time and also money, I think. I don't think that the association paid him to come. So, we are in such instances, some witnesses will even ask you that when they come, including police witness, IPOs, they will ask that when they come, you will have to pay their transport because nobody is going to give it to them. And they are coming on their own. So you have to promise that you will pay, or when they come, you have to pay them something, give them a token so that they can come again, especially if the case has been adjourned for continuation of trial. Mark my words, this is not payment for bribe or corruption. This is the incentivizing that I talked about in that article. When you read it, you understand better. So sometimes we have to do these things. So these are some of the reasons why the state does not have witnesses in court. Another constraint that we face with getting prosecution witnesses is that sometimes they promise to come and then on the D-Day they will not show up. I remember there was a murder case now, where we had gotten one of the inspectors, investigating police officers to come, and then we had closed his evidence, then we needed to call the second person. We had closed his testimony, then we needed to call the second person who did not come. We would call him, we'd write letters. And then he now took, asking the first officer to please liaise with him and get him to come to court before he would come to court. I remember the day that he came to court, and I was like, Sergeant so, because that's what was in the case file. And then he got angry because apparently he had been promoted. He was now an inspector, within the space of investigating that case. And the time that the case went to trial, he was now an inspector. So he took offense, and we had to now apologize to him. I remember that we were narrating this at work, and my deputy director just told us that the cheat code is to just address all policemen as officers. So instead of saying sergeant this, inspector that, and then, missing a very important title and getting them angry, which has also happened to my colleague, addressing an investigating police officer over the phone, we just call them officers. So that's what I just do. I just call them officers. So eventually, we're able to get him to court, and then he gave his evidence, bright, beautiful evidence. Imagine if we did not liaise with his colleague to bring him to court. That case would not have progressed the way it did, and his evidence was just very, very solid. He knew what he did in the investigation, and he was able to put it before the court. Very brilliant. Sometimes also, some policemen find it difficult, to express themselves or to put the evidence before the court properly. I remember an officer came and he had a tough time expressing himself properly in English and actually communicating the investigation to the court. Sometimes too, several IPOs are in a case, so you could get one to come to court, but it could be that his own part of the investigation was not that important, or was not the major thing, and then he might not be able to speak as to what the others did. But since they are a team, he can be the IPO testifying. I remember there was also an attempted kidnapping matter, and then the officer that I was able to get to come to court testified that he arrested the defendant, and then he was on night duty, night patrol. He was on patrol duty, so he arrested the defendant on the expressway, and then he handed him over to a team in another station, where they continued the investigation. But it was the one that I was able to bring to court of all the investigating police officers, and so he couldn't say much about what the others did, but he was able to say what he did, and then up till the point when he handed them over. So he could only, just say, okay, from what they recorded, they did this, they did that. But that defense counsel will jump up and say, yes, see evidence and all of that. So these are some of the constraints. This is not to excuse the state, but we're talking about what the state counsel does. So a state counsel goes above and beyond to bring witnesses to court. And these are some of the constraints of bringing witnesses to court. In the murder trial that I talked about, that we're able to get 2 investigating police officers, when it was time to get the 3rd police officer, it was very, very elusive and difficult. My colleague tried all that she could. I tried all that I could. We wrote letters, we visited police station, and then eventually he promised to come. And it was the last IPO that we wanted to take, and then we would close our case. So because in that case, the nominal complainant was afraid for his life and had absconded from court. So we're going to take the last IPO and close the case. On the D-Day, we were waiting for him in court. I'd already assured everyone on the team that he said he's coming. This time he's coming. Because I called him. I even called him the day before the trial, the continuation of the trial. I said he'll be in court. So then I now called him in court after we had expected him. That day, the judge had risen to do something, and they said that if our case was going on, he was going to sit again. I called this man, and he told me that he was in another state on election duty, and that it was, he was sent to that state, that very morning, that he had no idea that he would be going on election duty. And so there was nothing I could do. It was a frustrating experience. It was terrible, really frustrating. Of course, defense counsel that does not know this will come to court and tell the court that prosecution is wasting the time of the court. They would not know that we have done everything we can. This man has been seconded by his superior on the trial morning on election duty in another state. So there was nothing we could do. So these are some of the constraints that state counsel go through. Also, for civilian witnesses, sometimes some are afraid for their lives. Some cannot come because of circumstances beyond their control. I remember that there was a matter that we were doing. It was, how would I describe this matter? In that matter, someone had gotten a court order by fraudulent procedure to levy execution and take possession of a property. And so one of our witnesses in that matter was a bailiff of the court that had executed or helped to execute, that fraudulent order that had been secured in court. Fraudulent because it was secured with a faked proof of service on the defendant, who had no idea that the matter had even gone on, or that his property was, in question, or was going to be handed over to the defendant in our own matter, who was plaintiff in that fraudulent case, so to speak. So we had called the bailiff. He refused to come. We had tried to get him to court. Eventually, we had to subpoena him. So we issued a subpoena. It was implemented, and that was what brought him to court. So sometimes it takes subpoenaing, a witness before they show up in court. But how many witnesses are we going to subpoena? And it's a process, so it's not something that is done in a day. So this is why sometimes cases get prolonged. Sometimes we bring witnesses to court, and then the correctional facility will not bring the defendant to court. What do we do in those instances? We have to take an adjournment, and then we have to beg the witnesses to come again. And sometimes some will not come at the next adjourned date. So these things keep getting intertwined. And then at the end of the day, we say that a case has taken too long and prosecution has not been able to prosecute diligently. Sometimes we get to court and the court is not sitting, or the defense counsel is not present. So our witnesses have to go home without doing anything. I would say that the judge was quite understanding in our primary court. That's the court that we frequented. And he would often, especially if it is a police witness, an IPO, he would thank them profusely for coming to court and encourage them, admonish them to please come at the next adjourned date, explaining, the constraints, especially when it had to do with correctional facility not bringing the defendants or the defense counsel not showing up in court. So a lot of things go on, but the prosecution team, the prosecutor, the state counsel still has to bring witnesses to court. I also remember prepping a DSS witness once. I prepped and prepped and prepped the DSS officer, and then it was time for the case to be called, because usually criminal matters, because we had a primary court most times, they are called at the same time, following each other, so that we can just do our matters. The judge will always say that so that we can go back to our office and go and attend to other business of the state. So I prepped this DSS witness, and then they called our matter, and the defense counsel was nowhere to be found. And this was someone, I think I'd called him the morning before or something of the sort, because I eventually now resorted to calling the defense counsel, ahead of time, to remind them our cases, especially when we have witness, our cases this time, we expect you, please be in court, and then so that they will meet us and there will be no excuse and we can just proceed, because we really just wanted matters to move. I'm not saying that this is obtainable with all state counsel or prosecution team across the country, but this is what we did and this is what I did. So this is from an experiential point of view. But the defense counsel did not come that day, and we had to adjourn to another date, and the prepping went to waste for that particular day. Let us take a typical situation of bringing a witness to court. How does it go? So I'm going to use the attempted kidnapping matter. I'd called the ladies involved. They said they were not coming. I think one told me that she was going to come. She didn't come. One said she wasn't going to come. So, and when we called them, it's not that we just call them once. We have to call them like maybe 2 weeks before the matter, or 1 week before the matter. Then we'll now call them again like 2 days or 1 day to the matter, to ensure that they are coming and we are not just going on a full of our own in court. And then when we get to court, we look around for them. We have to call them again, start tracing them with our phone. Are you here? Where are you? What? Because we've not seen them before. Where are you seated? And all of that. So we have to do all these things. So then when I called the IPO told me I think he had been transferred to another team. And this happens a lot with police. In fact, for police, we have to write letters 2 weeks before. That's the minimum. If you write any letter that is less than 2 weeks, by the time the dispatch takes it to their office, they might even reject your letter. They won't take it. So now, I think the thing with police is that when you write a letter, you cannot be certain that your letter will get to the appropriate quarters, because the policemen are under authority. So they need to be radioed. They say what they use for it is this, signaled. They insist that even when we have seen the number of the IPO and we've called and it says, okay, I remember the case, I'm the one that handled it, or it's now in court, okay. So you have to write to like their commanding officer, their superior, to signal them. So we'll usually write to the OC legal or to the deputy commissioner of police. Do we write to deputy commissioner? Either OC legal or deputy commissioner, those two. So we write to their office, and then the letter has to go to a central place before it's dispatched to all the necessary units. And then we have to hope that the appropriate superior authority will signal that policeman to come to court on that day. And when they are signaled, sometimes you have to also pay their transport, because nobody's paying them for that, even though it's part of their duty. I wouldn't know why that is, but that is what we experienced. So, and then you have to follow up with phone calls. Sometimes the policeman is willing to come, but if it comes without a signal, they have told us in some instances that they will be punished for it. So, even though they know that the case is going on and we've told them and they are willing to come, the superior has to signal them. So, we have to just make sure that we do all that is within our power. When the time that we prosecuted, the person that was director of public prosecutions, would go to his office sometimes, and then he would just call the OC legal for us. The OC legal is a lawyer like us, even though she's in police. She's in the police force, so she would then do the needful to signal the appropriate persons to come to court. Because not coming to court also as a policeman for a trial in a matter that you investigated is dereliction of duty. But it's just that we have to follow the normal procedure for you to procure or to ensure your attendance in court. But absconding from court deliberately and without any authority to do so is also dereliction of duty. So very important. These things work hand in hand. So when we are able to we write letters and we make phone calls for police witnesses, for DSS witnesses, and other law enforcement agencies. Those are the two agencies that those are the two agencies that I had to deal with. Some other colleagues had to deal with Amotekun, probably with EFCC and NDLEA, but I think they prosecute for themselves, so I don't think that we have much business with them, except maybe we're transferring files and all of that. Then for civilian witnesses, we have to call them, because calling is basically the only link we have with them. We don't know them, we cannot go to their address because it's not safe to do so, one. Two is that sometimes these people have even moved away from the address they give to the police. If someone is living in a rented apartment and he has been robbed, and 2 years later the state is ready to go on with the matter, they probably moved to another area or to another state. So going to their address is not even an option, or to their workplace, that is not proper. So we have to call them, keep calling. Sometimes the numbers they have put down is not reachable, it's not going. So many things happen. Sometimes some of them, they are not so hospitable over the phone, but these are the things that we go through so that we can secure their attendance in court. And then when they come, what do? That's prepping the witness part. We ask them, so do you remember this matter? Can you tell us what really happened? So that we just with their memory, let them tell us what they remember. Then we now tell them what is in their statement, so and see if they can make a link if there are discrepancies. So if that is the case, then we get our story straight. This and this is what you'll be asked in court, and this is your response. No excessive answers, no scanty or insufficient responses. This is the way that you appear in court, and this is the way that you conduct yourself. We prep them. There's a whole video on the channel on prepping witnesses. Please go and watch. I'm happy that I made that video because someone left a comment to say that they thought that prepping witnesses means that you are influencing witnesses negatively. Not the exact words. That is not what it means to prep a witness. To prep a witness means to get ready. Even as lawyers, we get ready for court. You go over what you're going to say, your line of questioning, and how you're going to conduct yourself and all of that, what you're going to do. If this party does this, if they do not do that, what are you going to do? So you prep. So prep is just getting them ready. It's not teaching them to tell lies. So watch that video. I'll leave a link to it in the description box. Please watch it. So we prep them, we go over their stories according to their statements, because the statement is already before the court, so you cannot really deviate from it because of the front-loading system that we practice in Nigeria. So they need to repeat to the court most of the things that they have said in their statement, especially the important things. And as state counsel, we're not really in the proper position to tender their statements to the court. So the court will deal more with what they say. And then the defense counsel, if they need to contradict what they have said, they will be the ones to tender their statements and to contradict them on the basis of any discrepancies between their oral testimony and their written statements. So these are some of the things that a state counsel goes through. Even for police witnesses, there was a time in a rape matter. It's sad because in that matter, we had to restart the matter because when that was we were not on the team when the matter was started, but the prosecution counsel that done the matter had omitted to take the plea, and plea is very fundamental. So the case had to be restarted all over. So that case was restarted, and then we had to recall all witnesses to come back and re-give, if there's a word like that, re-give their testimony. So there was a police witness, IPO, that IPO is investigating police officer, by the way. There was an IPO that we wanted to bring to court, who had, been sent to, is it Kenya or Uganda? One other African country on a peacekeeping mission. She was no longer in Nigeria, so she could not even come to give evidence. So in that kind of situation, defense counsel or any other public member of the public will come and say the state is not serious. They can't even bring their witnesses to court. But here we are at police headquarters. Here we are. We have gone to we go to police stations a lot. Sometimes we take the letters physically ourselves, And then you go we go to and then we ask around, and then they tell us, go to this department. If you see so officer, then you can be sure that this officer will come to court, this will happen. So we go and there was a time they told us, this lady, she's already on peacekeeping mission outside of Nigeria. What do we do about that? The court will not wait for her to come, and members of the public are not that patient, neither is defense counsel. So these are some of the constraints. I also recall in another kidnapping matter, they had kidnapped members of an international institute, So one of the victims, direct victims that was kidnapped alongside others was a foreigner, And by the time that I was gathering witnesses, I was told that the foreigner had left Nigeria never to return after the kidnapping episode. They had paid the ransom, but now we were prosecuting the matter, so I had to get the chief security officer, and then I had to get one other officer in the institute, and then one other staff that was kidnapped alongside the foreigner, who were also listed as witnesses to give evidence in the matter. So these are some of the constraints. So, but this is also a key and integral duty of the State Counsel in the prosecution of a criminal matter, to bring witnesses to court and to prep them properly, put them in the dock and get their testimony before the court. So in the next video, we're talking about trial, how the state prosecutes, and particularly regarding trial. And then we'll talk about some of the other things that the State Counsel does. Most of my duties, we'll talk about issuing legal advice also. Not criminal legal advice now, because I didn't do that. We'll talk about issuing civil legal advice. I did a little now. I did a little of that. So you would notice that I'm more tilted towards the criminal litigation aspect and the mediation aspect. Those are the two departments wherein I worked, mediation department, public prosecutions department. So if I'm able to sometime in the future bring colleagues who worked in other departments, they might be able to provide some other, insights, because there are several other departments, about 6 other departments or 5. There's legislative drafting, there's parliamentary counseling, there's general legal administration, those ones that deal with prerogative of mercy and some other things. There's civil litigation 1, civil litigation 2, then there's public prosecutions, and then there's mediation department. So I speak more about the 2 departments, that concern me. So in the next episode, we'll talk more about criminal trial, the real deal, the action part. We'll talk about that. Then we'll also talk about other things and round up this series. And in the meantime, we'll talk about other things too on the channel. Don't forget, there are several columns or sections on the channel. Please check them out. There's a live stream section where you see the live videos that we do. There's a podcast session where you see when I've brought other lawyers to talk about their own experience and some topical aspects, topical issues, in law. There's a playlist section where you look at, how we have grouped some videos into playlists, so that you can watch things that are in the same area or things that are related, watch them at a go. And then there's the community section where we make posts and we ask ourselves questions. We take polls and we give out information and announcements. Currently, if you check the community section, this is January 2024, there's a form out for you to ask all your questions on tenancies, and they will be addressed at the end of the month in a question and answer session. Everyone who fills that form with a question will get a direct link, to join the session and participate in the question and answer. It could be a live that's if it's a live session, but if it's a recorded session, you also get a link to watch it directly if you leave your email. If you don't leave your email, if you don't have a question, you will still find it on the channel to join or to watch, as the case may be. Don't forget to buy my books. The link to buy is in the description box. And don't forget that if you need paid legal consultation or any other paid legal services, you can always book a paid session with a link in the description box, or send an email to the appropriate email in the description box, and you will be attended to. I'll see you in my very next video. Don't forget to subscribe and keep spreading the message of Bar Talk with Ola. To-dos.